Yes. You are there. Yesterday, Justice Nath was wishing you.
Yes. No, we miss him every day.
Special bench.
Not only yesterday.
Special bench at 3:30.
Yes,
You have been placed in a category with somebody, you know.
I heard about
You-
it.
Just will share the joke with us too.
Let's not.
he doesn't want to take it any further.
May it please, Lordship. Look, there's a problem in this matter, my lord. Your lordships have appointed one amicus first. There should have been at least two amicus first.
One for directs and one for properties. three, sorry. The third for the LDC.
One for the High Court, my lords.
For the heck.
Because the High Court's my lords are very reluctant, my lord, to provide data, to speak up what they desire, my lords.
That is the whole difficulty, Mr. Dwivedi.
Yes.
The High Court registry controls everything so strongly. Same as Supreme Court also. Registry is very powerful everywhere. So High Court also, the registry, if they are direct recruits, they will make sure that the promotees don't get their due benefits. And if the promotees are in majority there, they will hold back. That's the whole difficulty.
Because not only the registry, my lord, even the judges, my lords.
I
With
will
respect-
not talk about judges, but I know definitely for
Because-
it. They will not provide you the data. They will not place the file at the appropriate time. You keep asking them, file is lost, they are searching, this, that, everything keeps happening. Until you have a very good administrator at the helm.
So
Very
there are issues which can be raised factually, constitutionally. They do not, and unless, my lord, the data, as my lord Justice Chandran observed, my lord, unless the data is accurately presented before a lordship, there is a grave danger. There is a grave danger of doing something, my lord, which may cause serious imbalance rather than arriving at a proper balance. We create a situation that where there is balance already existing, an imbalance creeps in there, my lords. So that data, with great respects, is not there, my lords. One, my lord,
The High Courts are before us.
no, high courts are there, but the data.
You are for the High Court, so you should have placed the data on record.
So
like,
that's what I started. That has to be an amicus, my lord, who can pressurize. my lord,
Like
the
Mr. Thareekar
courts.
placed the data yesterday.
Yes.
So in the last so many years.
No, it's not. Your lordships want to lay down a uniform rule.
Yes, so therefore, so.
Therefore,
You are appearing for the High Court.
so
you
I'm
should have-
appearing for one high court,
You are paying for Allahabad High Court.
Allahabad High Court. I'm not appearing for all the high courts, my lords.
There are only three of them.
And most of the high courts are not represented, my lords.
They have been noticed.
No, legally speaking, I'm not saying that adjourn the matter. I'm not saying that.
The High Courts, all the High Courts as well as all the state governments,
But they,
all have been duly served.
I'm saying the data therefore is not before a lordship. my lord. And whatever data has been picked up, my lords, by the learned amicus, and I must say, my lord, he has faithfully reproduced from the various affidavits. But they are scanty, incomplete, and based on pre-existing, my lord, legal positions. We still don't know, my lords, your lordships have
That's
brought.
what Justice Vaidyanathan said yesterday. Now, with these two judgments, the dynamics may change.
So therefore, my lords, I stand up, my lords, on behalf of Allahabad High Court to dissuade your lordships from issuing any directions because it will create imbalance and high courts are in the best position. I will show from the learned amicus. And my dissuasion is firstly based on the constitutional plank. That's chapter 6 of part 6, Lord West's exclusive control in matters of appointment, promotion, postings, and control in the high courts. my lords. There may be some situations, I'm not saying that the Supreme Court should keep its hands off completely, my lord. There may be situations, my lord, where a lordship's interventions are required. But generally, my lord, the high courts are seized with the data and facts, and therefore, they are in a position to deal with the situation which prevails in the High Court in the particular state.
That's the reason, because every high court is taking different stance. The practices adopted in every high court are different. And therefore, some uniformity has to be there, whatever.
There cannot be. I'll show from the amicus's affidavit itself. Kindly have that affidavit. Look at the situation, how drastically it is varying. How do you bring about uniformity by a particular, it's not a question whether we should have quota. Next question will be, what should be the quota? Merely saying that there should be some quota is not enough. Where to have the quota? Where not to have? Whether to have? To what extent the quota should be? Should it be 10%, 20%, 50%? So, if the situation is varying, for example, my lord, in West Bengal, as my lord pointed out on the last occasion, there is a fair balance today existing. Now, any quota is bound to disrupt that balance. In Allahabad High Court, the age gap, which was 10 years, in the last 3 years has come down, Lord, is varying between 4 months to 3 years now. Because of the roster system and the holding of the examinations regularly in time and simultaneously every year in recruitment year, it has come down. Now to introduce, Lords, a quota system, A is unnecessary and B can create another balance. Lord, look at the situation, Lord, your Lordships introduced a quota in 2002, 50, 25, 25. In 2010, within 8 years, your Lordship thought, Lord, people are not coming, therefore 65, 25, 10. Another 10 years, Lord, again we say that it should be 50, 25, 25. So within a span of 18 years, 3 uniformities. So let the high courts deal with the situation. This is not that kind of a problem which is uniformly existing in the same manner in every high court. Now see, look at their amicus's affidavit. Written submission, sorry. And your Lordships have made some good changes because in the previous judgment, your Lordships have opened up the direct recruitment also. So therefore, Lord, now the whole 100% field is open, Lord, for the Civil Judge Junior Division to walk into the higher judicial service. If they are keen, if they are intelligent, if they believe in themselves, they should appear at the earliest, Lord, in that examination, directly to examinations, and they will be at par, Lord. But if they are diffident and if they feel that it's better to walk the longer route, as we know, Lord, that if you go to Amarnath, Lord, there are one short route, Lord, which is much more steep and risky, and the other through Pahalgam, Lord, and the other is through Sonmarg, Lord, which is a longer route and less.
Longer route, but which is the destination?
Yes, you reach the destination. And unfortunately, that's the problem.
Here the difficulty would be if you take other route, you will be lost.
No, here the destination is not selection grade, not super time. Here the Amarnath is the judgeship, my lord, of the High Court. These are not problems. Yesterday's argument, my lord, then I again obtained more data from the Allahabad High Court, and I find that in the selection grade also the promotees are much more than the direct recruits. I'll show that. So selection grade is also not an issue. Issue is the High Court judgeship. Because there, my lord, your lordships have some unwritten rules, what will be the zone of consideration, etc. And your lordship knows better than me, my lords, how, my lord, from the judicial service, They are picked up. If your lordship opens it up, my lord, to the entire zone of consideration is made the whole of this super time scale or the district judgeship. Every lawyer doesn't become a judge, my lords. That is heartburning. Heart is a very,
No, many
Fickle.
lawyers refuse to become judge.
many refuse to become judge, my lords. So maybe there is heartburning also. Why A is selected, why B is not selected, all those keeps on happening, my lords, everywhere. And there is no system of selection, my lord, that a lawyer who is more aged, my lord, he'll be selected, and who is less aged will not be selected. So these kind of heart burnings are normal. Heart is such a fickle thing, my lord, that is very easily burns, my lord. Even if the neighbor, my lord, is having a better car or a better fridge or something, it will burn. my lord. So we can't take care of heartburns. And rest, your lordship, my lord, since O.P. Garg's case, have been saying, my lord, that now we hope it will come to a rest. It will not rest. Whatever a lordship provides quota, this promotee versus direct recruit will go on. And it lingers, my lord, after becoming judge.
That has been a wishful thinking in many judgments, and still it's like that.
Yes,
It's not, this judgment will not be an end of the country.
not,
That-
my lord, right?
That both sides should,
Our effort is, my lord, to improve it. That's about all. Whether that improvement
betterment.
becomes, my lord, a deterioration, we don't know.
Well, it's always trial and error.
Therefore, leave it to the High Court, my lords. That's what I'm saying. If it is trial and error, my lord, it's let that authority which is constitutionally constituted, capacitated to do it, my lords. Force them to do it. As in the last case of age, your lordships passed an interim order saying let the High Court first consider whether age should be 61 instead of 60. Why should the High Court be bypassed, my lord? Then why should this be divested of their authority and power and duty? It's a constitutional duty of the High Court. Not only authority and entitlement, it's a duty, my lords. And it's time to strengthen the High Courts, not to weaken the High Courts. With great respect, my lord, your lordship may condone, my lords, my expressions. But things are gone a little too far. In this very court, a petition was filed, which is still pending. One of 2017. In concept note.
In
Concept note. On the basis of some letter from the government, a committee was constituted, and that committee was tasked to determine, my lord, whether this court should hold the selections and create a pool for recruitment to the office of district judge. That was the concept note. And that,
the issue with regarding All India Judicial Services on the pattern of IAS and IPS is always alive.
that authority, that's another grave breach of, kindly have a look at, let me complete this story, my lord, first before going to 312 All India Judicial Service, what it is. That committee headed by Justice Goel approved that concept note. Amicus was appointed and the matter was listed in the concept note in the court. So the whole selection will be done by the Supreme Court, and High Courts will now, my lord, just pick up. What remains of Chapter 6, my lord? It's dead.
But we are not inclined to do anything of that sort.
No, it's pending.
No, not even remotely.
After our resistance, the bench was disbanded. After hearing the matter for 2 days, bench of Chief Justice Kehar, Justice Goel, it was disbanded. We said, please, it's a destruction of the High Court. It's an elimination of Chapter 6. Now, my lords, what should be the qualification?
Even if we recommend to the college of some of the lawyers practicing here, you only suggest the names and leave it to the discretion of the High Court entirely.
But
In
here,
fact, we call upon those candidates, go and argue before the Chief Justice and the Collegium judges, and only after they find suitable, the names have been recommended even from the lawyers of practicing. before the-
that's good. That's very good, Mulaj. That's how
So
it should,
we thought that
that's
there-
how it should be.
We thought that there has to be some opening to the lawyers practicing here from
Yes.
different states.
Mr. Dwivedi, the instance which you are quoting,
Yes.
I am quite sure that you must be aware that what were the reactions by some of the high courts.
I appeared for the High Court, Mulaj, for 3 High Courts.
And I wish if a day comes when you display the online discussion, when the opinion of the High Court was sought, how some of the judges of the High Courts reacted, including me.
Yes.
So if there is an issue, there is a point, if there is a need to take a stand, we do take a stand.
That's right.
And I wish if that is displayed, and what I said.
It should be dismissed. But therefore, I'm saying, Lord, today we are fixing the age of retirement, we are fixing the quota, we are fixing the criteria, we are fixing, Lord, what should be the quota of the various sources, what should be the age eligibility eligibility. Then if you allow that petition also, Lord, concept note petition is still pending. Unfortunately, though it was adjourned, it was tagged with Malik Mazhar and it is still pending. So someday, Lord, somebody may feel, Lord, that it's time now to.
Honorable CJ has already hinted, it's the purpose is not to usurp the power of anyone. That
No, so but
constitutional power.
ultimately to introduce whether your lordship weightage or quota, that's the two broad suggestions. Your lordship will have to issue a mandamus, my lords. And mandamus for what? To make a legislation. The rule of the High Court is legislation at par with parliaments and state legislatures law, my lords. It's not a subordinate legislation. In some cases, they refer to it as subordinate. It's not subordinate. So you will have to issue a mandamus.
Court, it will be only as already hinted for uniform guidelines, for a kind of an infusement of the strength and for betterment of the,
Think-
not
Betterment and enhancing the efficiency, that's the only.
So what will the High Court do? High Court has to
Suppose-
follow it,
Suppose even.
and High Court can't amend it.
We don't know what we are going to do.
No, I'm
No,
dissuading.
if we accept any of the suggestions given by the learned abacus, even if quota is provided, it's not necessarily go by seniority.
No, I'm not on what your lordship will do. I'm
We are-
trying to dissuade your lordship.
We also don't know what we are going to do. That's what we are saying. But even if we do something of that sort, we will not be taking away the discretion of the High Court in recommending the names.
No, if
Names
the-
would be recommended
if-
by the High Court solely on the basis of their satisfaction with regard to the suitability of a candidate to be elevated.
if the discretion is of the High Court is not to be taken away, leave it to the High Court.
But why are you averse to having some uniform policy throughout the country?
No
Why
uniform.
should there be some different policy in the Bombay High Court and something?
Because in
that-
all aspects, with great respects, in all aspects, there cannot be uniformity, and uniformity
There can't be
is the wrong goal to say.
100% uniformity. Aren't there promoted judges in the every High Court? Aren't there direct district judges in the every High Court? Is there any distinction that say Madras High Court, 50% are direct district judges and 50% are promoted? When there is a uniformity in all that aspect,
So uniformity in this matter, my
and
lords,
you rest assured, we do not even indirectly, remotely intend to take away the discretion of the High Court.
my lord, uniformity in this respect, my lord, will be disastrous.
Mr. Dwivedi, you also please keep in,
Yes.
we are quite sure you are aware, some of the judgments have been cited. This court has already intermittently and in one or the 2, 3, 4, 5, 7 high courts, on the criteria or formulation of seniority has already interfered, leaving no scope for the high courts, leaving no scope for the discretion of the high courts. The full court decisions of the high court have been set aside here. And if a particular way of directions have been issued, in some of the cases, even ignoring the statutory rules, what to do? Are we not required to, in sitting in larger benches,
So
to
if-
rectify our own
Because
mistakes?
once the High Court makes a rule, if your lordship and matter comes before lordships in a appeal, my lord, the lordship certainly can issue directions. But today, my lord, here is an IA moved by an amicus seeking a direction to protect the promotees.
That's only everybody is giving their viewpoint. It's not that necessarily that we will follow that. way.
But this methodology, my lords, I'm with great
It's only
respect.
evaluation of the best of the possibilities that what can be.
Well, it's my humble submission, my lords, the lordships.
All right,
We record that
Because
we've
it's,
taken note of the submission,
Yes,
that
yes.
we need not do anything. All right.
Yes.
Now you proceed whatever you wish to say on the submission.
On the submissions made on the other side, including Ms. Makeja's, that there has to be a separate court of our LCD for elevation.
the lordship will take note, do whatever a lordship feels, my lord. I'm trying to I said,
No, we have recorded your submission. We have recorded your submission, as Justice
Yeah.
Raj has rightly pointed out. We should adopt the practice of hands-off.
A, hands off, and B, my lords, even if your lordship has to issue some guidelines or directions, it should be general, so that high court's
How
discretion.
many times have we been telling you that we don't even remotely intend to take away
Yes.
any discretion vested in the High Court?
That's my humble
That's
submission.
all right. It's only going to be a general direction. There is nothing like that intersessionality. We have already indicated to the other side also. There is no question of entertaining intersessionality dispute by us.
Now kindly have, my lords, the second plank, my lord, for dissuasion is the great divergence. So, amicus का note, amicus का note. Oh, नहीं, amicus का नहीं. ये amicus. Which page?
23.
Come to paragraph 23. Kindly come to paragraph 23, my lords. Amicus written statement.
Yes.
Paragraph 23.
Yes.
Yes, the chart.
Now kindly see, my lord, different states, what is the age gap difference? Andhra, Chhattisgarh, my lord, happens to be on the higher side. Gujarat is somewhere in the middle. Now see Haryana, only 2. This is not something abnormal, my lords. 2 years gap. Kerala is 4, Madhya Pradesh is 2. And next page,
Rajasthan 42 against 13.
yes. Barring the first 2, the rests are between 2 to 6. And if your lordship comes to Sikkim and Uttarakhand,
Yes, reverse.
reverse.
Sikkim, what was the strength of judiciary?
Now kindly have a look at paragraph 27. However, the situation is quite different in several other states, where promotee district judges are much more in number than direct recruit district judges at the post of principal district and session judge, district judge super time scale, as is evident from the following. In state of Chhattisgarh, as per the seniority gradation list of the cadre of district judges, out of 23 principal district session judge, 14 are promoted district judges. In state of Gujarat, as per seniority gradation list, out of 33, 24 are promoted. So whole list of high courts, Lord, which runs through at least 12 high courts, include 13 high courts, including state of West Bengal, which is at K, and Tamil Nadu is H. Delhi High Court is there. So where is the need, my lord, for
Reason for uniformity.
No,
It
there's-
will also be in the interest of the direct.
No,
recruits
this
where-
will-
where-
this-
where their position is.
No, this will keep on varying. It's not a question that this is a data based on the pre-existing rules. Now with your lordships opening the doors of direct recruit, many of these promotees will get an opportunity to,
If the dynamics change, the law will change. Where four of us would not be here.
that's not the point, my lord. To us, your lordships are lordships, my lord. We don't look at the faces.
You also don't, in the latter way.
Your lordship will have to look at the faces.
2010 changes.
For us, your lordships are all judges, my lord. So
2010
it doesn't
changes-
matter for us who is there.
2010 changes, 2002 changes in 2010, depending upon the circumstances existing there.
What,
25, 24, 25, many of the high courts feel that the changes made in 25, in 2010 need to be relooked into.
no, therefore therefore I'm saying that such is the variance that therefore there should be no uniform guideline, my lord, directed to the high courts because there is
On
so
the
much of
contrary, if-
variance.
if
Leave
this-
it to,
If this variance is removed,
it
will-
cannot.
It will balance the rights of all the stakeholders.
It's because, my lord, there is lot of other factors in play. Let me come to the other factor based on what is happening. my lord.
I'm sorry to interrupt, my friend. Para 25 goes one way, para 27 goes the other way. So there's a whole set of states in para 25 where the district direct recruits are more. Para 27 is what my
Where
friend
the
said.
promoters are.
So there's no uniformity there in
So
any.
that's what we are saying.
Whichever way you correct it, it's very difficult to create.
After 7, 8 years, you are right, the dynamics will change. Now with the 3 years practice at the bar, joining the service, judicial service, as rightly pointed out, part of eligibility for direct recruitment. So after 7, 8 years, the judicial officers will be eligible to compete not only for 25% LDC, but for 25% direct recruitment also. So there can be a possibility that suppose you have a cadre of 100 officers, junior division, out of them, 25 are selected in LDC, 25% are selected in direct, hypothetically, and only 50% are left.
But my lord,
So the
I appreciate.
still completely a new dynamics for
So-
interest seniority
No,
determination.
so,
We are right.
The latest judgment of 25, your lordships have proved the concept of LDC even at that level. So that will further give a fitting to the writer of the, I'm sorry. to it. I am-
But the impact of it will be only after 7, 8, maybe 10 years that somebody will be able to
We
evaluate.
will not be there. All of you will be there after 7, 8 years and again, take up that issue.
No,
Get it modified.
no, there's something much more than this.
Yes.
Look at the various other factors. Your lordship may have quota if your lordship wants, put weightage, whatever.
We are telling you, we don't know what we are going to decide.
No, I'm saying,
Therefore, at the threshold, one argument of yours we have understood. So you tell us what are your oppositions to the submissions made by.
I'm-
So that we can consider, we are not going to decide only on the.
no, my
basis
lord,
of the argument.
I'm not proposing anything, my lord. I'm saying don't do anything.
That's all, then let the
No,
others
but
argue. the-
I have to, no, it's not simply by saying ipse dixi, my lord, that I say don't do. Why you should not do it? That's the reasons I'm.
Come to the other factors now.
So now, there are various
Comparison में क्या क्या?
There are
tells that
there are
for applying the doctrine
there are
of Hancock.
various imponderable factors which operate, my lords, in determining whether there should be a quota, weightage, or not neither of them, or leave it as it is to the high courts. There are various factors. First is, my lord, why is there this age gap? Age gap, my lords? None of the petitions affidavits are throwing any light as to why, my lord, the judicial officers in the civil divisions, civil judge junior division, are reaching late, my lords. If a lawyer gets an LLB degree at 22 or 23, before your lordship's judgment, there was no bar, my lords, in appearing in the examinations for the junior division. But lawyers were not appearing at 26. The average age of the lawyers appearing in the examination is the most important factor, my lord, which get. In Allahabad High Court, it is 28. Now, please get this data from all the high courts. This is very important. They are all crying about the age gap, increasing age gap. Even Shetty Commission emphasizes. The reason is that lawyers are appearing in this examination at a late stage. Your lordships have not barred the door. It's their choice. I have a choice to carry on with my practice. I have a choice to refuse judgeship. I have a choice to appear in lords in the 7 years examination upon reaching 35 years and go straight to high HJS. And I have a choice, my lord, to go at the earliest, at the lowest rung and take the long route. So an individual lawyer is exercising his choice. And if I exercise my choice at the age of 30 and 32, I'm bound to be there, my lord, the age gap will be there. And in the examination experience in the Allahabad High Court is that the average age is 28 years. We have mentioned in our affidavit, if your lordship has that affidavit.
This is volume 3, R1, page 1.
Volume 3, R1. हमारा affidavit. Now, if average age is 28, which shows, my lord, that the large number of people are appearing in the examinations beyond the age of 30 years. And none of the promotees are giving your lordships a data, my lord, from different high courts as to what is the average age. Now, if I choose to appear at the age of 35 and become a munsif, my lord, and then I complain, my lord, that I don't get a fast track. So these are the problems which are existing there, my lord, and these facts are not before your lordships. Whatever solution your lordship will find will be in the absence of material data. Kindly have paragraph 7 of my affidavit. And now your lordships have put a 3 years bar of experience. So they will appear naturally, my lord, at a later stage. That's a further. Earlier there was no bar. Now, in the interest of efficiency of service, my lords have rightly put that bar. So therefore, my lords, it's not a question of a difference of age gap between the two groups and who is reaching and who is more or who is less. You have to keep in mind the whole overall efficiency of the judicial system. That's the most important thing. And that's why, my lord, this 3 years bar has been put, notwithstanding the consequence being that they will be delayed. However, even if 3 years is taken to 23 to 3, 26 and 26, before 35, nobody can appear. So they complete 7 years also for directly appearing. So who prevents, Lord, this judicial officers, now that your lordships have opened the door, they should compete, Lord, and whoever is confident about himself, he will come, Lord, then in the direct recruit, you'll also find that half of the direct recruits will be, my lords, promotees. So let us see the fallout of what your lordships have already provided.
They will not be promoted, they will be appointees.
Sir,
How did they be promoted?
no,
If they are selected, they will be direct recruits.
no,
They
no,
will be promoting.
no, from their group, I'm not, they are from the judicial.
It is not as if that their initial service will be counted and they will get a retrospective or something.
No, I'm
It will
saying,
be a fresh appointment.
and of course, it will be fresh, but the civil judge junior division by this route comes faster into the district judge. That's the important news. So therefore, this permutation and combination which your lordships have now produced, let us see, my lord, we are, my lord, sort of
Yes.
hastily, my lord, moving ahead.
What is the
with
next
another.
Mr. Dwivedi, what is the next point now?
So lordship may kindly note, my lord, I have indicated at paragraph 7, the minimum age 28. Now, there is a small note, my lord, which I have prepared. If the lordship has that note, allows me to, my lord, place it.
Similar to some competitive solution.
What is it called? The mouse.
May I quickly just take your lordship through this note, my lord, just a small note. The submissions of the learned amicus are founded on the factual premise of increasing age gap between the direct recruits and promotees in the HAS cadre. As per para 23 of his note, it appears that there is no uniformity as regards age gap in different states. In West Bengal, Chhattisgarh and Madhya Pradesh, there is broad equivalence between the two categories. And in Sikkim and Uttarakhand, the promotees are younger in age. In Haryana and Madhya Pradesh, the gap is a negligible 2 years. Even in Jharkhand and Kerala, the gap is only 5 years. Further, in para 27, it is pointed out that there is not much difference in the average age of promotees and direct recruits. Reverting to the additional affidavit of the Allahabad High Court dated 25/10/25, it would appear that from the year 2012 onwards, the age gap has come down drastically from 10 years to between 4 months and 3 years. There is some variation on account of different factors. One of the factors for the relatively higher age for the recruitment of HJS is that several of the candidates appear in the civil junior division examinations when they are 28 years of age or above. Ordinarily, a lawyer would be eligible to appear in the examination at the age of 22, 23 years, as earlier there was no limitation of 3 years practice at the bar for appearing in the examination. Even after the stipulation of 3 years practice requirements, they will be eligible to appear in the age of 25, 26. Ordinarily, the civil judge junior division takes 10 to 12 years of service before being considered for promotion to HJS. Since the minimum age for HJS is 35 years, normally there should not be occasion for substantial age gap between the two categories. In para 7 of the High Court affidavit, it has been stated that the year 2022, the average age of selected candidates for civil judge junior division was 28 years. This indicates that a sizable number of candidates were above 30 years. In para 9 of the aforesaid affidavit, a chart is included which shows that from the year 2008 to 25, the promotees are occupying 75% or more of the post in the HJS cadre. So far as the post of district judge stroke equivalent posts are concerned, it is stated that there are in all 268 posts, of which 75 posts in 75 districts are of district judge. The rest are equivalent posts. Out of 268 posts at present, there are 103 direct recruits and 148 are promotee officers. At present, there are 70 district judges, of which 12 are promotee officers. According to the information obtained from the High Court on 28/12/25, there are 233 posts in the district judge selection grade, which constitutes 35% as per Rule 27 of the UP HJS rules. Out of these 233 posts, only 34 are direct recruit officers and 198 are promotee officers. So even in the selection grade, my lord, they are in large numbers, much larger than the direct recruits. Out of these 233 posts, only 34 are direct recruits and 198 are promotee officers. One officer is from LCD. There are 78 posts of district judge super time pay scale. Out of these, 65 are direct recruits and 12 are promotee officers. The letter from the High Court is enclosed. I have a next note. Yesterday, I got this information, which is at the end of this note. Apparently, the situation is not at all alarming as has been projected. Moreover, the inter-C configuration at different levels is a fluctuating phenomena and would vary from time to time. Para 16 of the additional affidavit, it has been stated that since the year 1990, a total of 200 officers from HJS have been elevated to the High Court. Out of these, 133 officers were promotees and 67 were direct recruits. Considering the elevation at different points of time, it is apparent that from the chart that up till the year 2009, the promotees elevated in the Judge of High Court were far more than the direct recruits. Between 2010 and 2019, 32 direct recruits were elevated, and while 27 promotees had been elevated. So almost a fair balance. After 2019, the promotee officers is 11, while the direct recruits are 26. The fluctuation is on account of more than one reason, which is happening. So when a crop of younger civil judge division are there, they will remain and get a longer term. But if
You must also keep in mind that the direct recruits quota is much bigger than the direct, the promotees quota is much bigger than the direct recruits, and see the numbers.
So therefore, I said in the beginning, my lord, the target is that, then it is there, my lord, that some internally some changes should be there, so that the whole of this is.
That is actually to be examined whether or not to do anything.
Yes. But that has been prevailing since long. That's up to, my lord, that's not the issue, my lord, before the lordship. That's entirely within the lordship's domain, my lord, what to do or not to do. It is submitted that according to the written submission of the learned amicus, in several states, the promotees are much more than direct recruits at the post of principal, district judge super time, see para 27. States mentioned are so and so. There is no similarity in the position of different states. In most states, either there exists a broad equivalence or the promotee officers are larger in number. This is apart from the fact that the numerical interrelationship is of a dynamic nature and is variable. Therefore, the prayer sought for ought not to be accepted, and the matter should be left to the High Court to tackle any imbalance which may exist. Now, my lord, I may just inform your lordship now that it has also happened in the Allahabad High Court, and my lord Justice Pittamnath must be knowing, my lord, that sometimes, my lord, there are vacancies in the civil judge senior division level, and enough candidates are not available because of the eligibility requirement. So the High Court has been granting relaxations, my lord.
That's right.
Lordships are aware, my lord. So it's not that the High Court is, my lord, closed its eyes and doing nothing, my lord. So whenever a situation requires in the interest of judicial efficiency, administrative efficiency, the High Courts have been, my lord, alive to the situation.
Many times that is necessitated because of the jurisdictional issue, like in a monetary suit or even in.
We don't have the specific number of minimum officers to be placed in every district.
Yes. So that relaxation is always in public interest.
Yes.
That is done. Most of many high courts do.
I have mentioned about it. I have quoted your lordship's orders, my lords. I'm not reading them, recent judgments. And my plea is, my lords, that please wait and watch and see, my lords, what is the fallout of these judgments. Maybe, my lords, in a year or 2 years' time, my lords, we'll have fresh data, my lords, as to what is the fallout, what is the imbalance.
Yes, sir, that is
But
already-
exact equality, my lord,
that has already been argued.
exact, lordship may Pardon me for repetition.
This was the 8th or 10th time that you are arguing the same point.
But the point is,
It's not like hammer that if you do it 12 times, then it will have more impact.
we don't know, my lords, what will have impact. You know, we argue in a state of uncertainty, my lords, and not knowing what is impacting. My lords.
Correct.
So therefore, your lordships, and my lords, so far as the position of the Allahabad High Court, something was said by two learned counsels, my lords, that the promotees and the direct recruits are not being, my lord, recruited in the same recruitment year. And if the promotees are recruited in year A and year 1 and the direct recruits in year 2, so they can't then be, my lord, put in through the roster system above. But that's not the position. After 2012, earlier, my lord, there was a problem. Number of litigations which came up to this court, my lord, where vacancy determination and other aspects, promotees versus direct recruits, because of which, my lord, the recruitments were held up. But after 2012, every recruitment, the recruitment year is same. The advertisement, my lords, for selections and appointments and all the 3 grades are being issued simultaneously. The letters of appointment are being issued simultaneously. So it's not a case where, my lord, there is a different recruitment year. So I agree, my lord, that there should be the same recruitment year, at least in this court. I don't know about Bihar, but in Allahabad High Court, my lord, this is happening. And in fact, in the previous year, when we sent the notification, my lord, to the state government, they issued for the direct recruit first. We sent it back to them. No, all 3 should be issued simultaneously. So all those issues, my lord, don't arise. Which Ms. Mayuri, my lord, and Dinesh Trivedi, they were pressing about the roster being same. So far as Allahabad is
So
concerned.
you agree with Mr. Dinesh Trivedi on one aspect at least, that the quota should exist only.
I really disagree, my lord.
No, you also said that you agree that the quota should be only the recruitment, only for the recruitment year.
No, I'm not saying anything. I'm only saying that in Allahabad, this problem doesn't exist.
Because Allahabad has been regularly holding these elections.
And we are filing the affidavit in that Malik Mazhar case also.
We have already clarified, it's not Allahabad High Court or Punjab Haryana High Court.
Because unfortunately, I can explain my position. I don't know the data of other high courts. There must be some problems in some courts.
General principle. So when
Yes.
you are saying 1 year roster points, are you also agreeing to that the direct recruits, say on hypothetical basis, if people recruited in 2020, 2025 and occupying a roster point which will remain unfilled in 2019 or 2018?
So, my lords, your lordships have in such cases taken a view that if the roster system has broken down, the authority concerned, either the High Court or the Supreme Court, should come to a conclusion that the roster system has broken down. For example, my lord, in Justice Rohinton
That is,
Nariman's-
wherever it is broken down, continuous length of service, that
Then,
is
my
a
lords,
settled law.
then that roster will not apply. But if merely because, my lord, one selection happens in December 2018 and the other happens, my lord, in February 2019, one can't say that the rule has broken down. So it all depends, my lord, whether your lordships on facts can conclude because of the long gap. For example, was in 2018,
15 SCC.
15 SCC 439, in the Allahabad High Court, this problem was there. Between 2002 and 2009, when there were litigations because of which so lordships lord said that we will not apply the rota system.
But must have been broken down.
That's how lordships have done. I'm not citing that. The judgments, my lord, which I've,
Law in all services.
some of the judgments which I mentioned in my petition are contained in this compilation for convenience. So that's my submission, my lords. I have cited judgments also. For example, my lord, in one of the cases which came before your lordships in Asia resurfacing, a direction had been issued by this court, my lord, Justice Nariman, that since in criminal petitions of quashing, interim orders are granted by the High Court and then that matter doesn't come up. So the order had been passed by this court that if within 6 months the High Court
That was-
doesn't
that was
decide, then
rectified.
the stay will be vacated.
That was rectified.
Yes, so I filed a petition on behalf of the. So we have been trying to get these things rectified.
Right.
So I'm only saying, Lord, that.
If errors are there, they are bound to be corrected.
Yes. So these things, Lord, that will keep on happening, and as a part of the system. That, in my humble submission, Lord, is one that on account of the exclusive competence which
Yes.
Constitution has reposed, Lord, in the High Court, Lord, its discretion ought not to be curbed, at least not curbed drastically, Lord. Second, I submit, Lord, that there is so much divergence, so much variations, and it is dynamic. Whatever the Lordship will do tomorrow, rest assured, Lord, the Lordship will find that this one-to-one will never come across, Lord. This age gap disappearance will never happen. There will be some this gap because of the fact, the manner in which the lawyers exercise their choice. So for all these reasons, please leave it to the High Court, Lord, at least with some minimal guidance, and that's my humble submission. I'm grateful. Volume 2, R1 is my main written submission.
Thank you.
Please, Your Lordships.
Yes.
Your Lordships, I appear for the Honorable High Court of Punjab and Haryana.
Because I wanted to get All India Judicial Service, which your Lordship mentioned.
Yes.
Would your Lordship just look at Article 312?
This provision, Mr. Yogi?
Of course, All India Judicial Service is the best solution. I'm sorry,
This
Art-
provision are you referring?
Even-
Article 312. I'm sorry.
No, High Court is willing for that.
No, I don't know whether Supreme Court will be willing, my lords, unless, my lord, we don't know. Just look at this. It's a very dangerous provision, my lords, introduced during emergency. And I'll be filing a PIL, my lords. Just look at. This is surprising. It's on many basic features are being violated by this. Notwithstanding anything in chapter 6 of part 6 of part 11 of the council, if the Council of States has declared, see only Rajya Sabha, by a resolution supported by not less than 2/3 of the members present and voting, that it is necessary or expedient in the national interest so to do. Parliament may by law provide for the creation of one or more All India services, including an All India Judicial Service. Note the number, my lords, 1976.
1976, yes.
317. Common to the union and the states, and the subject to other provisions of this chapter, regulate the recruitment and the conditions of service of persons appointed to any such service. The services known at the commencement of this constitution shall be deemed to be services created by Parliament under this. We are not concerned. 3. The All India Judicial Service referred to in clause 1 shall not include any post inferior to that of district judge as defined in Article 236. So district judge goes out of chapter 6 if this happens. The rest remains in the. Now this is the most
Fourth.
objectionable. The law providing for the creation of the All India Judicial Service aforesaid may contain such provisions for the amendment of chapter 6 of part 6 as may be necessary for giving effect to the provisions of that law, and no such law shall be deemed to be an amendment of this constitution for the purposes. So now you bypass 368 and amend, my lord, chapter 6, which has been held to be basic part of the basic feature and independence of judiciary. 368 itself is basic feature, that's also bypassed. And resolution is only of Rajya Sabha which is required. Of course, Parliament comes in later on.
Parliament comes, so
Yes, Parliament will make
the bill has to be by both the houses.
by ordinary laws. Just as the law blows in
When they say.
fortunately, no party had 2/3 vote majority in Rajya Sabha, so that resolution is not coming.
So after the golden jubilee of that amendment, you want to challenge it?
Sorry.
Yes,
Please,
sir.
Please, Your Lordships. Your Lordships, I appear for Honorable High Court of Punjab and Haryana. I filed my written submissions, but before, my lords, they are short submissions. Before I take Your Lordships to the submissions, my lords, I would like Your Lordships to look at the rules very quickly, which, my lords, are at page 721, volume 4A. PDF 721, volume 4A. Your Lordships may kindly have page 723. I'm sorry.
723 of what, madam?
Of volume
Volume 4A,
Roman 4A.
soft copy uploaded. Is at PDF page 721.
My lords, it starts at 721. Your Lordships may kindly have at page 723.
That is
I'll-
page
I'll be-
711, 713.
723, my lords, I would like to show Rule 7. PDF 723.
Yes. Method of appointment.
Yes, my lords. So, my lords, I'm not reading the whole thing. Your
Yes,
Lordships
page
can see.
723. Volume 4 मिल गया?
Please, Your Lords. Your Lordships, I'm not reading the whole rule. The percentage, my lords, is based on All India Judges Association's ratio, my lords. At that time, it was 65% by promotion, 10% by LDCE, and 25%, my lords, by direct recruitment. Now, my lords, of course, we are pursuant to the latest judgment, my lords, we are in the process of restoring 25%, my lords, to the LDCE. Then, Your Lordships may kindly have seven subsection rules, sub-rule 4. Sub-rule 4. These posts shall be filled in accordance with the roster attached as Annexure B. I'll be taking Your Lordships through that roster. That, Your Lordships, thereafter, Rule 8 is assessment of merit, because arguments were raised yesterday that there is no subjective assessment of merit, my lords, when for the promotees, when they are promoted. So, my lords, the rule says for assessing and testing the merit and the suitability of the member of Punjab Civil Services Judicial Branch for promotion under clauses of sub-rule of 3 of Rule 7 of these rules, the High Court may hold a written objective test of 75 marks and viva voce of 25 marks, and then take into consideration the ACR. So, my lords, this is the process for them. For the limited written competitive examination, Rule 9 applies, my lords, where there is a written examination which is much more elaborate and which is for 600 marks, and assessment of record 150 marks, and viva is for 250 marks. Then, Your Lordships, I'll request Your Lordships to have a look at Rule
It comes seniority recruitment.
Yes, my lords, I'm coming.
There is a written examination.
Yes, my lords, I'm coming. So Rule 12 deals with the seniority. And Your Lordships, the Rule 12 in crux says that the seniority after the appointment to the cadre from all sources will be as per the roster. That's what it says, my lords. And so it will be as per the roster 12D. The inter se seniority position of the officers appointed in the services under Rule 7 shall be as given in the roster annexed. Now, yes. Your Lordships, also 12 sub-rule 2, a person recruited to the service under clauses A, B, C by all the sources, my lords, 3 sources of Rule 7 shall take his position in the seniority list as shown in the roster attached as Annexure B, irrespective of the date on which he is actually joining the service. So, my lords, it's not the date of appointment, but it is the roster. Now, Your Lordships may kindly have the roster. Roster is, my lords, at page 730.
So, has been introduced when?
My lords, these rules, my lords, are of They have been amended various times though, your lordships, but the rules are of 2007.
Rules are of 2007,
Yes,
but
my
when
lord.
this rule was.
Roster is, my lords, after the All India Judges Association's second case, my lords.
This roster system has been introduced when?
2007, my lords.
By the order of, by the order of.
Now-
2024.
2024.
Rule 12 has been substituted by notification number so and so, dated 19th of August 2024.
No.
The footnote. At least
My lords, Rule 12 was amended post the judgment.
substituted, yeah.
Yes, my lords, post the judgment. And that is why it says 2024. Only Rule 12. The rules have been there with effect from 2007. Now, your lordships may kindly have roster. My lords may kindly have roster, my lords, is at page 732. And that is under sub-rule 4 of Rule 7. So it has been prior to, since 2007 only. 732.
Your running page is 722.
732.
That's the PDF page.
Please, my lords, PDF page.
The running page which you have
Running
mentioned,
page is 722.
722.
Yes, my lords. I thought, my lords, PDF will be more convenient for your lords.
The running pages are there straight away. Why?
Please, your lords, I'll use. Now, your lordships may see, there are first 3 points on the roster which go to promotees. The 4th point goes to the direct recruits. Then again 3 points, wave 5, 6, 7 go to the promotees. 8 goes to the direct recruit. Then, my lords, 9, 10, 11, and my lords,
10 goes to the,
10 goes through the limited competitive examination.
that is because of the 10% reserve.
Yes, my lord, because of the weightage, my lords. Because 65% promotees are there. So they have, that's why the roster starts with them. And my lords, only 10% limited departmental examination are there.
This will have to be changed now.
This will now be changed because your lordships have restored it to 25%. Now, your lordships, so these are the rules and this is the roster. And so, my lords, after the additional district judges are appointed by various 3 sources, my submission is that they lose their birthmark, they become one cadre, and their seniority is decided by the roster. I would humbly submit, my lords, that the roster has worked for us. Now, your lordships, I will show the data. Now, your lordships may see, and my lords, the apprehension of the learned amicus that promotees are lagging behind, both in terms of designation, elevation, and age, doesn't hold true, my lords, in our High Court. So, my lords, I will show the data. My submissions, my lords, my written submissions are there, my lords. I'll show 2, my lords. I'll show my written submissions, and then I'll also show my reply affidavit. So, my lords,
Madam, you should be correct on record.
please, my lords.
The roster has come into force only in 2024 after the decision of this court in relation to an inter-se seniority dispute. The original rule 12 did not contemplate any roster system.
My lords, maybe we are wrong, but our instructions are that.
Maybe you are wrong.
Please, my lords, your lordships would know better. Your lordships would know better, my lords. My lords, I can't contest that. I can't contest.
There's not any dispute on facts.
Yes, yes. So, my lords, may kindly see, volume 2. Message volume 2, my lords, the written submissions are there, and running page R2, my lords, volume 2 R2, and page number 1, my lords. Your lordship has it. So, your lordships, first is the issue framed by your lordships in your lordship's earlier order as to what should be the criteria for determining seniority in the higher judicial services. Then, my lords, I have reproduced the rules, etc. That I won't bother your lordships with. And at para 4, page 3, is the criteria for designation as the district judge from the cadre of additional district judge. So, Your Lordships, para 4, thereafter, for the ADJs to be promoted and designated as district and session judge, the following criteria has been framed by the High Court. He has earned at least 2 good reports during the last 3 years preceding the year of his consideration. An officer with good record of service and whose latest grading is B+ or above shall only be entitled to be considered for designation as district and session judge. 3, he has not been assessed C below average during the last 5 years preceding the years of his consideration. 4, he has not been assessed C integrity doubtful during the last 10 years of his tenure in the superior judicial services. An officer undergoing punishment awarded by the full court shall not be considered for designation as district and session judge during currency of the punishment. The zone of consideration shall be 3 times the number of vacancies up to 5, and if the vacancies are more than 5, then twice the number of such vacancies, subject to the minimum of 15 officers in the later eventuality. The cases of additional district and session judge in the consideration zone be placed before the Honorable Screening Committee with a view to examine the suitability of the officers for designation as district and session judge before placing the same for consideration of honorable judges. Now, my lords, for the inter se seniority, my lords, besides the issue framed by your lordships, the apprehension of the learned amicus are, as expressed in his application, that promotees are lagging behind, or if they are being designated or elevated to the Honorable High Court also, the age that they get is, they reach there very late. So, my lords, these are so therefore, my lords, it has been prayed by the learned amicus that para 29 of All India Judges Association, where the roster system vis-a-vis weightage was examined, and the recommendation of Shetty Commission regarding the weightage was not accepted, and what was accepted was roster on 2 grounds: that it gives to less disputes, it gives rise to the lesser disputes, lesser inter-seniority disputes, and it is a fairer method. And also, my lords, the Honorable Court relied upon the earlier judgments relating to other quotas, my lords, and said that those 40-point rosters have worked. So, my lords, these are the prayers that my learned friend is asking. Now, my lords, let us examine, my lords, our data in the light of, my lords, what has been submitted. So, my lords, may kindly have the running page 11 of my submissions, where I've given a table, my lords. If your lordship permits, I'll read para 14 along with the table, which is at page 10 bottom. Para 14 starts at page 10 bottom. Your lordships have it?
Yes.
Yes. So the state of Punjab and Haryana, the apprehension expressed in the state of Punjab and Haryana, the apprehension expressed by the learned amicus in the application does not exist, as the ratio of promotees and direct recruits promoted to the post of district and session judges 2:1 and 3:2. In the states of 2 is promotees, promotees versus vis-a-vis direct recruits. In the states of Punjab and Haryana respectively, that the roster system appended in the service rules of the respective states itself ensures that the promotees who make up for the 75% of the superior judicial services have proportionate opportunity for promotion. Further, the data in the last 10 years shows that the ratio of promotees and direct recruits who have been elevated to High Court is 13:3, 13 promotees and 3 direct recruits, and 12:4 in the states of Punjab and Haryana respectively. Detailed breakup of the data is as under. So, your lordships, in the table, these are the number of the judicial officers. This is total number who form the ratio of promotees and direct recruitees of 5:1 entering the higher judicial services. So, promotees are 240 in number in Punjab, and direct recruits are 47 in Punjab. Similarly, in Haryana, promotees are 239, while there are 47 direct recruits. Similarly, on the next point, number of the judicial officers who form the ratio of 29:15 and 31:21 promoted to principal district judges. So the learned ADJs who have been promoted as district judges, they are 29 from amongst the promotees and 15 from amongst the direct recruits in Punjab. and 31 from amongst the promotees and 21 from amongst the direct recruits in Haryana. Then number of judicial officers who have been elevated to the High Court in the last 10 years are 16 in total in Punjab, out of which there are 13 promotees and there are 3 direct recruits. In Haryana, there are 12 promotees and 4 direct recruits. Now, your lordships, I'm not taking your lordships through the Haryana rules because they are same. Now, your lordships may kindly also see I will request your lordships to have a look at my affidavit by Honorable High Court of Punjab and Haryana. Page. Volume 3, your lordships.
Volume 3.
Volume 3.
3A.
3A.
1428. 1360. 3A. 1428.
Volume 3, 3A.
3A.1.
1428. Actually, we need to go to 1446.
That's it.
It starts at 1431, your lordships. I'm sorry. It starts at 1431. 31.
Just show me that.
It's an affidavit of one Mr. Jaspinder Singh.
Yes, 1431.
Yes, Miss. Your lordships, along with this affidavit, we have also annexed the gradation and the seniority list of judges in the district judge cadre, and also, my lords, the ratio of judges promoted, which is the same, which I have taken your lordships through it. So your lordships may kindly have page 1433, and there is a table there in para 5. 1433.
Where is the gradation list of the place what is needed?
May I, your lordships?
Running page 1421.
14, Milos, I'm requesting your lordships to have a look at para 5, 1433.
Yes.
Yes, Milos. So,
Oh, running page 1433.
Milos, running page is Milos
1433
1433.
is all right, yes.
Yes, Milos. Para 5.
Para-
Deponent is placing on record the information sought in paragraph 5 of the application. So the gradation seniority list of judges in the district judge cadre, I have annexed as annexure R1 for Punjab and annexure R2 for Haryana. Then the ratio, my lords, I have already taken your lordships through in my submissions, is 5:1 total ratio of the total promotees and direct recruits. And then, my lords, the average age of judges promoted through the civil judge cadre as compared to the direct recruits in the district judge cadre. So promotee officers, the average age is 46 years, and direct recruits is 40 years in Punjab. And my lords, in Haryana, it is 43 vis-a-vis 1. 43 for promotees and direct recruits 41 years. Then, my lords, ratio of promoted district judges and direct recruits who have been appointed as principal district judges, 29:15, 31:12. This I mentioned in my submissions also. Now, my lords, my submissions are that my learned friends, my learned amicus prayers, that para 29 of the All India Judges Association, wherein, my lords, the Shetty Commission's recommendation regarding the weightage was rejected and roster was accepted, should be modified, or in the alternative, 50:50 or 1:1 should be done. My lords, my submission is that once, my lords, all the officers are appointed as additional district judges from these 3 sources, then they lose their birthmark. And, my lords, they become one cadre and they are all equal. So equals should be treated as equal. and there should not be any quota provided. This submission is, Milos, dehoards the fact that in the data of the Honorable High Court of Punjab and Haryana, in fact, Milos, promotees are more than the district direct recruits, both in the cases of Milos elevation to the Honorable High Court and also Milos as having been Milos designated as district judges. So in both the on both the counts, promotees are more. But despite that, Milos, in law, Milos, my submission is that Roshan Lal Tandon, I squarely applies to my case, and your lordships are very well aware, I'm not reading it. And so, Milos, therein also the birthmark is lost. They are all one cadre, they all must be treated equally. The other judgment is Milos Atul Shukla. I mentioned all these judgments in my submissions, wherein Milos, the different age of superannuation was provided for 2 sets, depending upon the source they came from. So Milos, therein also it was held that they are all equal and they must be treated as equal. Milos, we called the, Milos, I'm sorry, I may be wrong, but we called the High Court, and the instructions that we got was that the roster has been under Milos in operation since 2007. Milos, subject to correction, these are our instructions, Milos.
Not in Rule 12, it was in Rule 7.
Rule 7, Milos. Because Rule 7 says the seniority will be as per the roster.
But you are referring to 12.
Rule 7.
Rule 12, it has been
Yes,
introduced in
Milos,
2024.
12 was later on amended.
7 only pertaining to the determination of ratio in recruitment, where most were there.
Your lordship's roster is also there in Rule 7.
You are right.
And seniority, in relation to seniority.
Seniority rule is.
Your lordship, may I read may I read?
12 has been amended only in 24.
12 is amended in 24. Your lordships is right. And Milos, may kindly have Rule 7 once more, Milos. Your lordships may have 7, sub-rule 1, sub-rule 4, your lordships. These posts shall be filled in accordance with, it doesn't use the word seniority, they shall be filled in accordance with the roster attached as Appendix B. But Milos, our instructions are that after these appointments were made through different 3 sources, they have been placed in these sources, in this roster for the purpose of seniority since 2007. So all this data, Milos, I have given. My instructions, Milos, are that this data is the result of the roster system. And so therefore, Milos, the roster system has proved to be successful in the Honorable High Court of Punjab and Haryana. And Milos, there is no such discrimination, both in terms of age or designation as district judges or Milos, this elevation to the High Court. And your lordships, there is one more chart which I would like your lordships to see. This is Milos in the last 10 years. We also wanted to test it, Milos, independently. So we called for this. In the last 10 years, Milos, this is the data for with effect from 15 to 2025.
Of elevation.
Please, Milos. Of elevation to the High Court. Total judicial officers elevated as honorable judges, 16, 13 promotee officers in Punjab and 3 direct recruits. And average age on elevation was promotee officers 57 years and direct recruits 55 years. Milos, I would say, Milos, it can't be exact.
Up to which date?
Milos, this is up to 1/1/2000, from 1/1/2015 till date.
Till date.
Till date.
So in 10 years, only 16 judicial officers have been.
13 plus 3, 16, Milos. Only 16.
I think the last college we have.
Milos, in between there was COVID years also.
32.
Milos, 3 years were COVID years.
3 years were COVID years.
3 years were COVID years.
Can't be only 32 in 10 years.
1/3 of the sanction stream, that is 9. 90 ka 30.
No, High Court judges.
94 is Punjab, Haryana.
Milos, I have,
1/3, so 30.
In 2020, there was no appointment. Because in 2000,
Average.
in 2020 and in 2022, during the COVID years, there were no appointments under either of the quotas.
Yes.
And Milos, may kindly see the last thing, the average age is 57 vis-a-vis 55 in Promoti and direct recruits in Punjab. And Haryana, it is 57 and 56. So, Your Lordships, with this, Milos, I end, Milos, by saying, Milos, that as far as Punjab, Haryana and Haryana High Court is concerned, the roster has worked, and Milos, the apprehensions of the learned amicus, Milos, have no basis. Oblige you.
Thanks.
Best argument should have been.
May I please, Your Lordships? Lordship, to put in a nutshell, I appear for direct recruitees in IA 251959 of 25, 251959 of 25. They are some direct recruitees from Kerala, and IA 270501 of 25, some direct recruitees from Bihar.
Yes.
On behalf of these direct recruitees, my lord, my humble submission would be, it's not necessary to disturb on an all India basis the rules that are framed, which are in force. That would be my ultimate submission. There is no requirement of a change of rules, would be my humble submission before your lord. I'll quickly refer to the reasons for which I say this. Right at the beginning, my lord, I would like your lordships to see right through in the Indian judiciary, we have accepted that lateral induction of members from the bar at higher levels is required and necessary for the health of the institution. I would request that we do not look at it, my lord, from the point of view of some individuals who have been denied promotion or getting promotion. Maybe we'll have to look at it from the point of view of the health of the system. That will be the proper way to look at it. Not a trade union type of an approach where each person says, I did not get it, I did not get it. But the point should be what would contribute to the health of the system as envisaged under the Indian judicial system. For which I would like to bring to your lordship's notice observations in Dheeraj Murray, two places, my lord, where the advantage of having members from the bar recruited at higher levels is recognized. Can I take your lordship through that, my lord? 2027 SCC 401, para 29, 85 and 87 would be the relevance. Giving it.
5B, 5B, first part, 5B to 5B, not A to B2, B2. There's no B, A and R. R2. B नहीं है, A and R. No. R1?
Volume 1 is R1. Is it?
Page 140.
No more a good law.
No, it may not be good law. I'm not trying to follow anything that is laid down there. Observation as to why lateral induction of members from the bar is relevant.
That is there in City Commission itself in 2002. If the Shetty Commission itself recognizes,
You know, the reasons are perhaps stated more clearly here. That's why I wanted to just bring to your lordship's notice that aspect. The
Volume,
para 29.
R1.
R1. Please inform this correct volume.
Let's say R1.
so nobody disputes that the lateral entry has been provided in order to enhance the efficiency of administration.
Right. That's
Not 1 hour.
what I wanted to point out to your lordship. And
That is found in 2002 also.
that's why I said, my lord, right from the beginning, right from the very early days, decades earlier, we have accepted this principle of get all the volume correctly, so that this much of time should not be taken. Can I go on, my lord? Lordship has got it. Paragraph 29 and 87, I would read 87 because that should be enough. 87. The constitution makers, in the opinion of this court, conscious.
Paragraph
87,
87.
yes. 29 also similar observations are there. I'll be satisfied by reading to 87. The constitution makers. Para 87.
205.
205.
20.
PDF page 208.
Yes.
Yes.
The constitution makers, in the opinion of this court, consciously wish that members of the bar should be considered for appointment at all the three levels, that is district judges, high court and this court. This was because counsel practicing in the law courts have a direct link with the people who need their services. Their views about the functioning of the courts is a constant dynamic. Similarly, their views based on the experience gained at the bar injects the judicial branch with fresh perspectives, uniquely positioned as a professional, an advocate as a tripartite relationship, one with the public, the second with the court, and the third with her or his client. A counsel learned in the law has an obligation as an officer of the court, to advance the cause of his client in a fair manner and assist the court. Being members of the legal profession, advocates are also considered to be thought leaders. Therefore, the constitution makers envisage that that every rung of the judicial system, a component of direct appointment from members of the bar should be resorted to. For these reasons, it's held. The point that I want to urge before your lordship is,
Read further.
you want,
Read the next sentence.
please, my lord.
For all these reasons.
It's held that members of the judicial service of any state cannot claim to be appointed for vacancies in the cadre of district judges in the quota earmarked for appointment from amongst
This
the
is overruled.
eligible. That's gone. That's
This
gone.
is overruled.
That's gone, my lord. There is no doubt about it. The point is, why?
So therefore, the best judgment on which you should have relied on ought to have been 2002, which still holds the field.
Right, my lord. The latest one, why I rely on that,
This one is the one which is overruled.
Lord, overruled on the question whether they can gain entry as a direct recruitee. That is all that is there.
No doubt with regard to the proposition that the lateral entry is provided in order to
Right,
infuse
only, I'm
efficiency in the administration of justice.
only on that point, my lord, because this lateral entry people should also be not frustrated, must be properly looked after. And that's the point that I'm trying to make before your lordship, that the grievance of the other section promotees cannot be looked at it in isolation. For the health of the system, it's very important that people directly recruited also have avenues. They also have career progression, which is assured.
Nobody doubts about that.
Yes.
Nobody doubts about that proposition.
My lord, next submission would be if the type of
The question is
weightage,
only whether their as-
weightage.
The question is whether only their aspirations have to be looked into,
No, that's not
or
what
the aspirations of all.
exactly what I'm saying, not the aspirations of the other side alone. This side also has to be
There's
looked
no
into.
dispute on that proposition.
Right, my lord, that is very evident, my lord. Both have to be looked into is my, yes.
So that's what we are saying from the beginning. That's what we are saying from the beginning, that aspirations of all have to be
Right, I will be,
into proper perspective.
I will be trying to show before your lordship. I will be trying to show before your lordship.
Nobody disputes, at least neither of five of us dispute that proposition.
Nobody disputes, but my point is,
Then either promotee is not direct recruiter.
we should not. That is, in the interest of the promotees, the interest of the direct recruitees cannot be compromised, is the humble submission that I'm trying to make before your lordship.
Very
Right, that's clear. My lord, the next point that I want to make is, when an integrated cadre is made of two sources, from two,
They lose their birthmark.
yes, they lose their birthmark. I would rely on three decisions on this point, my lord. Roshan Lal Tandon versus Union, I'm not going to take your lordship through that. Roshan Lal, then Triloki, and a 7-judge bench in Davinder Singh. I want your lordship to see that. That is at page, paragraph 93, volume R2.
Same volume, page 230. We have page 230. Huh?
Say 152. 152. Para APC.
93.
97, 87.
Para 93.
Yes.
Yes.
153 is the patient. 153 is the patient.
Para 93, you have
This para,
Para 93, in the SCC para 93.
This is the Punjab judgment,
Yes. Yes,
the classification.
I'm not taking your lordship through all the detailed discussions, my lord.
para 97.
93. No, it starts with Nakara, principal is stated.
Yes.
Yes. I invite your lordship's attention to the statement of the law there. Thus, a class which is not similarly situated for the purpose of law can be further classified. The test that the court must follow to determine the validity of subclassification of a class is as follows. That is the point that I wanted to point out here. Now there is a classification as district judges, the common cadre. Can there be a subclassification? Under what circumstances it can be? That's what I'm trying to point out there. Now, the test is whether the class is homogeneous or similarly situated for the purpose of the specific law. If the answer to A above is in the affirmative, the class cannot be subclassified. If the answer to A is in the negative, the class can be subclassified. My humble submission would be the cadre is homogeneous, similarly situated persons, and therefore.
You read those things. Further, the class can be subclassified upon the fulfillment of the following standards.
Yeah. Yeah, my lord. If that is, if the answer to the first portion is no, then only that comes. The
difficulty is that the judgments have to be read as a whole.
It has to be, my lord.
Not once.
Ultimately.
The practice here is that one sentence is here and there are pointed out.
No, ultimately, the law is laid down by them in these lines. And therefore,
You have to read C also.
yes, see, if the answer A above is in the negative, the class can be subclassified. The submission is it can There can be a yardstick of intelligible differentia further classifying the class, and the yardstick must have normal nexus with the object of the. Now here, if it is homogeneous and they are similarly situated, there is no question of a further classification. That's the point that I'm trying to urge before you, Raja. In this case, all of them are from different streams have come into the common cadre, and having come to the common cadre, on the basis of the streams from which they came, you cannot make a sub-classification. That's what.
After Sangam there, it's Ganga.
You know?
After Sangam, it is Ganga.
Right.
There can't be
They,
different Yamuna.
they cannot be a further classification of a homogeneous and similarly situated group is a submission that I make.
With your respect, no, that is not entirely correct because Ganga flows into the delta which comprises of both Brahmaputra and
Okay.
So that's the further classification.
Okay, we are only here, Your Lordship, and my point is, when the integrated
That's
cadre.
what which Acharya also argued that once you
Nakara is also-
enter a cadre, then the birthmark is lost and you are
Roshan
But-
Lal and everything.
Right. That is very clearly stated in Triloky also, my lord. When they come from two different sources, when they merge into one and the common category comes, thereafter your birthmark is lost and there cannot be a distinction on the basis of the source from which we came. Here, distinction is attempted to be made on the basis of the source from which we came because the argument is they have service in the judiciary and therefore they can be distinguished or further classified appears to be the argument that's there. Your Lordship, find it cannot be because look at the other side, my lord. Later on, you cannot say for every 5 years of practice, you will get one weightage. You cannot say that obviously. Just as you can't say when the integrated cadre comes, you cannot later on contend that I came from the judiciary and therefore 5 years of weightage or a quota for promotion. And the other side can also, the ridiculous nature of that argument can be seen from the fact, supposing the member of the bar were to argue that I have come from the bar and therefore 5 years I must get a weightage. Is any?
But this court has done that for pensionable services of the High Court judges. It has said that the judges coming from the bar, they will be entitled to 10 years additional for getting the pension.
That is, your Lordship is referring to the service in the
Justice
bar
Saraswat-
to be counted.
This is Saraswat judgment.
That is for the purpose of pension. That's for the purpose of pension, it's mentioned, yes. Yeah, my humble submission would be, when they come from different sources and merge into one source, integrated cadre, similarly situated cadre, thereafter, you can't make a distinction based on the birthmark that where you came from. Other considerations can happen. Last time, my lord was putting the question, supposing there is a better educational qualification, that would be a different situation altogether. All the decisions holding otherwise would only say that it's a different criteria, not the source from which you came. When the source from which you came cannot be the basis for distinguishing or discriminating between the two different groups. And therefore, it would be my submission, my lord, it's not possible for us to, on the basis or the length of service that one has at the bar or the other at the bench, as a judicial officer, to further subclassify them on the basis of their birthmark, on the basis of the source from which they came. My lord, the next question is, I think just Mr. Dwivedi has already adverted to that aspect. I'll just mention it. What is the basis for this? Why do they want this to be further restrictions or improvements to be made to the rule? There are only two things that are stated. One, that there is bunching of direct recruitees on the top. That appears to be one argument. There is bunching of direct recruitees at the top, and the second is the age difference. These are the 2 points on which they are. My lord, bunching is a phenomena which has arisen because of not making the selections promptly. It's a matter of the past. After Malik Mazhar decision, there cannot be. We need only enforce the law. We need only enforce the directions in Malik Mazhar. Every year, the selection has to be conducted. And every year, everything is mentioned. Can I invite your lordship's attention to Malik Mazhar also, my lord, please?
Page number 483. 5A. with 5A, 5A1. 483. So this is the.
Five A.
Your lordships are aware of that. I just want to particularly point out here.
Five A, Roman five, capital A. Page number, previous page 487, otherwise 483.
Paragraph 7. Have a look at paragraph 7. I'll take your lordship to 7A and B. We direct us here and there.
487.
My lords have got it. Can you see, my lord, that A is with regard to direct recruitees. And B is in respect of recruitment from by promotion, 50%. Kindly see, my lord, the number of vacancies is to be ascertained by 31st March in both cases, A and B. Or the dates on which examinations are to be conducted, everything is mentioned, and ultimately the orders have to be passed, issue appointment order by 30th September in both cases. What I'm trying to point out before your lordship is, now this has to be followed. We need only insist that this must be followed. No change of the rules is required. If there is human failure regarding compliance with these, we have to correct that. Now, if that happens, your lordship finds, every year we will have both categories of people ready for absorption to the common cadre, and there will be no bunching as it is now alleged. Now, your lordship will go, if we go through the seniority list, you will find number of direct recruitees are bunched together. This happens because both in Bihar as also in Kerala at times, this happens because in due time, the selection do not take place, which malady is not there now. If Malik Bazar is followed, there can be no question of bunching at all. There is no question of selection for various years being bunched together and the direct recruitees or the promotees coming in one lot occupying the entire position. So that what my submission before your lordship would be that in the light of Malik Bazar, there is no possibility now, except in violation of that judgment, of any bunching together. And therefore, the possibility that the promotees will have to wait until the entire list of direct recruitees are exhausted is a story of the past. It will not anymore be there. To counter that or to provide against that, it is not necessary for us to amend the rules. That is what I will let us submit before you.
But the other side of this very principle will be that in light of now Mazhar Malik, that every high court is obligated to hold the annual examination and go for annual recruitment process. Where is the necessity of assigning roster points for the purpose of seniority?
I'll come to that. That's the next point that I have to make. The lordship point, so that what I am saying, we know from the both streams, we have people selected, appointed also.
It's an annual feature.
Right.
Annual feature.
Right, annual feature.
Both recruitments will never take place together because the examination is different.
Exactly.
Merit cum seniority criteria is altogether different than direct recruit.
Right.
Direct recruit is normally different than the LDCE.
Right.
Therefore, all three will be different selection process.
From each stream, the persons to be appointed are selected, right? From each stream, person to be appointed are selected. Now the question is, how do you appoint? Supposing 3 persons are selected from one stream, do you appoint all of them together on top? Supposing 5 persons promotees are selected, do you appoint all of them together at the top? That is where the principle of roster comes from. The principle of roster comes so that you may have selected people from various sources. They will not together join the mainstream. That is where the roster becomes important. Your Lordship, I found such a lot of grievances against the roster. I believe the roster is something which ought to be accepted gracefully, because what it seeks to prevent is, again, bunching of selectees from one particular stream for one particular year together. To avoid that, what is said is, there shall be a roster. Now, it is referred to as a 40-point roster. I am unable to understand how the 40-point comes.
What is the genesis or the history of introducing roster? Was it not essentially meant only to ensure the representation for the constitutionally provided reservations, which were unfortunately being overlooked and ignored
Right.
by most of the states throughout the country?
Right. Now, whatever may have been the historic reasons that the roster came into existence, here the purpose I explained to my lords. Now, all the 3 streams, people are selected. Now, my lord's decision in All India Judges case, 50% to one, 25% to one, 25% to the other. If all the 50% together are appointed on top, that would work out injustice. And therefore, my lord said,
A direct recruit is appointed in January and a promotee comes in December of that very year. What is wrong if that December appointee ranks junior to the January appointee?
well, I would say all the appointments are to take place together. If you follow Malik Mazhar, all the appointments are to take place.
If it is only when you have a ready-made list of the direct recruits, you have a ready-made list of LDCE, you have also a list of the promotees, and you are to give appointment to them all together. They are entering the cadre together.
Right, madam.
There the question of, you may be right, that how to place them in bulk at one place than another, that may arise.
Right. That,
If the appointments are at different points of time, then where is
Lord,
under which law there is a
my
compulsion of
humble
roster?
submission would be, after Malik Mazhar, there is no question of appointments being at different points of time. That's why it took a lordship to Malik Mazhar. Malik Mazhar, from the date of publication to date of appointment, is the same date. And therefore, appointments will be made on the same date. And while making that appointment,
To what extent it is followed?
no, my lord, if it is not followed, it's for us to enforce that and not change the rules for that.
Issue contempt,
With great respect.
issue contempt notice to the High Courts.
Yes, madam?
Issue contempt notice to the High Courts.
To the judges of the selection.
Now, your lordship, whatever, I don't think the High Court would be interested in violating the directions of this court. The possibility of violation should not persuade us to amend the rules. That's what I'm submitting. What are we worried about? We have issued specific directions in Malik Mazhar specifying the date on which the appointment is to be made. All 3 lists must be ready on one particular day. And for that, the court very gracefully said, don't appoint them, bunch them together to follow the roster. That's what it said. Your lordship, and that's all that is said. They said the 40-point roster. I think the 40-point is a misnomer. 40-point will not be there. It will be only, as of now, 50% to one, 25% to one, 25% to the other. So at worst, at best, it can only be a 4-point roster.
For according to you, an annual roster is the ideal answer to this situation.
Right. It is the answer, not my suggestion. That is what Malik Mazhar says. That is what para 29 of All India Judges case decision says when it said roster. But it said 40-point roster. I'm not able to understand how the 40-point roster would come in, because there are only 3 sources. 2 for promotees, 1 for direct recruiting, 1 for LCD. And then therefore LDC, and therefore there is no question of a 40-point roster. Many of the high courts have said 4 plus 4 plus 4 plus 4 made it 40. It's not necessary. It's a 4-point roster. According to me, it's only a 4-point roster. And then your lordship finds ideally, I would suggest what should happen is the promotees, they having been in service, give them the first 1, 2, and then 3, the LDC, and the 4th, the direct recruitee. And therefore, there is no chance of people being bunched together to deny the legitimate aspirations of those coming lower. This is what's para 29, which when it spoke of the roster said, though I must confess the 40-point roster usage of that expression does not appear to be very correct. 40-point roster would come only where the constitutional reservations come. Here, a roster, read the 40-point roster as only a roster. And in that roster, the purpose of the roster is very evident. Don't bunch people together in one. You give them this 2 plus 1 plus 1. That is the purpose. And if that is followed, my respectful submission will be all the assumed the difficulties, imbalances that are there will vanish. And as pointed out by the Allahabad High Court, it is vanishing also. It's not necessary to do that now. It's already done. It's already done. It's being followed. I'll take your lordship the Kerala rules and again try to convince your lordship on that. Your lordship, and therefore, what is required is the 40-point roster will now be, because there was one 10%, 65% and 25%, there was some confusion. Right now, after the last judgment by this court, all that is required is it has to be promotee 1, promotee 2, LDC 3, and direct recruitee 4. As simple as that.
Yes.
For this, is it necessary to amend the rules is a question I would request my lords to consider, and my humble submission will be kindly do not do that. It's not necessary at all. Right.
Thank you.
No. Sorry. I'll complete now. Your lordship finds the other aspect has also been urged. Now, your lordship finds the question is today the fact scenario is very, very different. Direct recruitee 25% also these people can get in. LDCE, your
That
lordship.
is already argued. Mr. Singh.
Yeah,
There's no point in again repeating the same argument.
Right. I just want your lordship to be reminded of that because
So that has been argued time and again that now the dynamics have changed. Mr. Dwivedi also has argued that.
that's what I said. I accept what Mr. Dwivedi submitted on that. Now, your lordship finds. Now the next question is, my lord, from the entry grade district judges, when they go to the next higher of the selection grade and the super time scale, what happens? That's the next point. The lordship can kindly have a look at the Kerala rules. The Kerala rules from the entry grade to the selection grade, it is only merit. It's only merit. I want to read your lordship the rules. If at all any rules are to be maintained, identical rules on the Kerala pattern has to be maintained, made elsewhere. It is only, please see that, rule 2.2. It is what is submitted by the Kerala High Court, isn't it? I can read, yes. Your lordship, it says, it speaks like this, madam. Appointment to 35% selection grade posts in the service shall be made by the High Court with effect from the 1st January 2020 from amongst the members of the service on the basis of, now comes it, merit and ability, seniority being considered only when merit and ability are equal.
But that is broadly same criteria everywhere.
Yeah,
Merit is the first emphasis.
yeah.
Seniority only determines the zone of consideration.
Right.
Rest is the ability and suitability.
Your lordship, from all the next, I wanted to read the next line also.
That's why
Next-
Madam
next-
Maninder Acharya
only-
points out.
Only approved probationers with 5 years service shall be eligible for being considered for promotion. So that whoever has completed 5 years is eligible to be considered. Forget about where you come from, which stream, all of them are eligible.
Mr. Basant, we don't think that there is a single high court having criteria of seniority cum merit or seniority cum fitness or seniority cum suitability. Every high court has merit, then cum maybe ability, maybe seniority, maybe suitability, maybe anything. But first emphasis is on merit. So selection in promotion quota has to be there purely on the basis of merit. Seniority will be only for the limited purpose of identifying the zone of consideration. That's all.
Right, my humble submission would be, and therefore the grievance that we are lower in the seniority list is not going to affect your movement upwards to the selection grade or thereafter. That's what I'm trying to point out. So that your lordship finds, well, how it is being enforced, your lordship may clarify that it has to be purely on the basis of merit. And pursuit of excellence is an axiom under 51A or the fundamental duties also. And therefore, your lordship finds, in the light of the rules that we have in Kerala, which identical rules, if your lordship wants, the others can be asked to, and it can be directed that strictly this movement from entry point district judge to selection grade shall be only on the basis of merit. And therefore, what happens is the question of seniority lapses into insignificance. You don't have to upset the seniority for this purpose. They would still be on top if they have merit and ability. So that where is the need to amend the rules to accommodate something which is already there? If they are good, if they are meritorious, they come up. There are many sources by which they can become the entry cadre district judge. From the entry cadre to the next higher level, selection grade, it is going to be only on merit, and therefore your seniority does not matter at all. And therefore, to give you a position in there, it's not necessary to amend the rules at all.
Yes. What next?
Yes.
That's all.
Now, the same position relating to movement from selection grade to the next grade also.
But-
That is the super time scale. Now, my lord, can I take your lordship through the Kerala rules one? The Kerala High Court's affidavit. Please see that affidavit, my lord. What is the position in Kerala? Is it necessary to invoke the 142 powers to interfere with something that is happening in Kerala? Affidavit. Yeah.
As my learned brother pointed out, that we are not considering state-wise position.
Emila? No.
Not considering state-wise position.
No, I want to point out that if no amendment to the rules is required, the rules presently in force is sufficient. Now, if at all your lordship feels it is necessary, extend this rule to other places is what my humble submission would be. Your lordship finds an amendment to the rule to provide quota, amendment to the rule to provide weightage is not necessary at all, and maintenance of separate seniority lists are not necessary at all, because the malady which we are trying to cure, the solution is already there.
In the Kerala rules.
Yes.
So you want the Kerala rules to be model rules to be followed by all these.
All the
Now, my lord, if your lordship feels that such a clarification will be given so far as the others are concerned, please do that. Please do that. Please make it clear that the seniority shall be on the basis of the order of appointment. Now, the order of appointment will get posted according to the roster. And now thereafter, the promotion from there will be not on the basis of the seniority at all, but purely on merit. And if that is so, there can be no grievance. Now, we don't want to promote somebody who is not meritorious and go to the selection grade. Only those who are meritorious must go in. Your lordship finds the want of merit cannot be used as an excuse to go up the ladder. Because your lordship finds from the entry cadre promotee district judges, your lordship finds what will happen is all of them, all the entry cadre, they are people who have not qualified for, they have not come for direct recruitee as per the last decision. They are people who have not succeeded in the LDCE. For them, who have not got into the selection grade, for them to protect their interests, please don't think of an amendment to the rule. It's not necessary at all.
You have understood that?
You understood?
Yes.
Thank you.
No, just one. I just wanted your lordship to see the Kerala situation as reported by the High Court. Will your lordship kindly see paragraph 7 of the Kerala High Court's affidavit?
Mr. Giri has already pointed that out.
Yeah.
I read out the affidavit.
Yeah, he has read out the affidavit.
Now, what is of importance is, my lord, the statistics given there shows out of 30,
So that was read to us yesterday by Mr. Giri.
yes, 80,
He has already read it to us, his affidavit.
right. I just wanted to bring it to your lordship notice again so that it stays with your lordship, because it is important so far as the Kerala rules are concerned. They do not result in the apprehensions which are aired by the amicus. That is what I want to point out.
So that is already pointed out to us by the learned senior counsel appearing on behalf of the High Court of Kerala.
High Court, unfortunately did not take a specific stand as to whether this should be there or that should be there.
Rightly, because the High Court can't,
You know,
High Court can't, but the
why, what is,
actual position was pointed out by the council.
what is just and fair? The High Court must have the guts to.
So how could the High Court afford to take a particular stand that they are promoting,
No, I will-
they are supporting promoters or they are supporting direct?
I will not say that, but it is up to the High Court to take a stand on what is fair and just. We can't avoid that. We can't avoid that responsibility. And it's for the High Court to point out to the court, as they have done in this, and analyze and show that the apprehensions of the amicus are non-existent in Kerala. That is what I wanted to point out.
Yes, thank you, Mr. Prasan. Thank you. Who is next?
I am also in the same application, though my sequence is in the end, Milord. I may be
So
also.
in one eye, only one council can argue. So your name is there in some other eye.
I just wanted to apprise this court that I am in the sequence in the end, Milord, though I am also representing few of the direct community, the same application.
So
I wanted to.
in so far as one application is concerned, only one senior council can argue.
I am also there, therefore yesterday I said I am with him, Milord.
Okay, that's
That's why I said yesterday. I am-
What-
Your presence is marked.
Yeah.
What has happened is, my lord, there were 7 applicants. I continue with 4, 3 have gone to others. And
That's the reason I said.
that's why he is coming out. 7 applicants originally.
You are not appearing for anybody from Punjab and Haryana.
No, Milord, for the timing I am.
And-
I am south only, Milord, but not so far.
So South has been,
I'm trying to, Milord.
That's all.
Thank you, Lord.
yes, Mr. Prasan.
May it please, your Lord. Lord, I am appearing in IA number 260414 of 2025 for the direct recruits in Delhi. Now, my Lord, I have 3 or 4 submissions to make. I adopt what has already.
You have also shifted venue.
No, my Lord, actually, by the time the Punjab people came, I had already appeared for Delhi, so I could not appear for the other side in Punjab. But what I am submitting, I am going to submit, I am adopting what Mr. Dwivedi said and what has been argued earlier. But I have 2 or 3 particular submissions to make on one argument address, whether weightage of any sort is necessary to be granted or not. Second, on the roster system, which according to me is a very good system. It has not failed, but it has not been given a chance to operate properly. And my third submission is going to be on the quota, which cannot be granted. Much has been said. I just want to refer to 2 paragraphs. But before I come to that, my Lord, please have my written submission, just 2-3 paragraphs to show that Delhi actually presents the other end of the spectrum, as which the learned amicus pointed to your lordships. It is volume 2, R1, page 1 to 9, 1 to 19.
So then what is the reason? If certain states, it's dominated by promoting, and if it's certain high courts, it is dominated by directs, then some rationalization would be in your benefit.
So my submission is going to be, my Lord, that the 2002 judgment in para 30, while rejecting the argument of weightage, introduced a concept of roster. And para 30 weightage is rejected by saying roster will take care of it. Now, unfortunately, in the working of the roster, there have been 1 or 2 problems. And the main problem is the delay in the selection process of the direct recruits. On account of the delay in the selection process of the direct recruits, this roster could not work properly, because what then happens, and what has been falling from your lordships, is promotee comes in, say, year 2007. Process of direct recruitment also commenced in 2007. It is completed in 2009. By the time the direct recruit comes and then makes a claim that I should be given a seniority from 2007, it perhaps becomes a little too late in the day for it to be granted. And then your lordship's judgments have also leaned in favor of length of service. This is what happened in Delhi, in B.S. Mathur and the 2 earlier judgments. Even though the rules had rota quota, but because of delay in direct recruitments, the court ultimately said, no, let it be length of service. But all that, I'm just wanting 5 minutes before that, please have this volume 2, R1, page 1 to 19. Now, kindly have first, internal page will be 2 and running page will be 4. There is a para 6. Your lordship got.
The factual position.
Factual position in Delhi is, just 2-3 paras, I'm not going to dwell much on. The factual position in Delhi is that promotees far outnumber the direct recruits in the post of principal district judge, since out of 12 posts of principal district judges, 9 were promotees and 2 were direct recruits. Please turn over the next page, my lord. This first column is direct and then promotee. So there are 4 direct in 2022, 7 promotees. And if your lordship will go down the chart, my lord, in January 25, there was no direct principal district judge. And now there are 2 and 9 are promotees. Now please have para 7. The factual position in Delhi is also that during the period 20 to 25, 17 judges from the district judiciary were elevated to the Honorable High Court of Delhi, out of which 15 were promotees and only 2 were direct recruits. Then, my lord, we have said the situation in some other state also remains the same. Of course, this, your lordship has a much better chart given by the amicus, which Mr. Dwivedi read. Those 13 states, I don't need to read it again. He has given that better chart. Now, my lord, as so far as age is concerned also, if your lordship will come to page 6, running page 6, para 10. The factual position is that the average age at the time of appointment as district judges for both promotees and direct recruits is similar. The average age of appointment of both direct recruits and promotees is in the range of 40 to 41 years. There are instances of promotees being appointed even before the age of 35. We have 3 such people who were 34 years and plus when they became. There are numerous instances of promotees becoming district judges between 35 to 38 and 38 to 40. Then, my lord, I will not read the whole of it. So age also is the same in Delhi. Average age is 40 versus 40.6. So promotees are negative by 6 months only. And I have that chart. I will give it to your lordships, my lord, but your lordship may take it. Now, we have said in some other states also, the position remains the same. So far as Delhi is concerned, the promotees actually are taking a larger share, both at the stage of principal district judge and also at the stage of high court. Now, one other point which I want to point out is at page, because this will then, in the course of arguments, I will be referring to these facts, page 16 running, page 14 internal, para 28. In fact, if I can start from page 13 internal.
Paragraph?
Para 27, that fresh para, last 3 lines at the bottom. It is submitted that whereas appointment of direct recruits against vacancies for a particular year is delayed due to administrative process, on an average, the process takes 2 to 4 years. However, promotees are appointed speedily upon arising of vacancies. Now, here that roster will come, and what my lords were, Justice Suryakant had also observed, that will it be yearly? Why should they get the slots? There are rational answers to that, my lord. I will attempt to give them to your lordships just after I finish reading this. Now, promotees are appointed speedily. As a result, between the period from arising of vacancies and initiation of the recruitment process for direct recruits to the eventual appointment of the direct recruits, several batches of promotees get appointed. In such situation, the application of the rule for determining seniority from date of appointment works in a matter which is grossly unjust and unfair to the direct recruits. Now, we have given instances, my lord, the recruitment notice of Delhi, which was issued in December 13, the left-hand side column, final result is declared in July 15, and direct recruit is appointed in September. In the meantime, in the year 13 itself, 52 promotees came and joined. This is page 14 internal, my lord, in the chart. Yes. Now, similar is the position every year. Now, in the 15 recruitment, the result is declared in 17, and the direct recruits come in May 2018. And during this time, 47 officers are promoted from 16-17. And then, my lord, in 17 again, direct recruitment, final result is issued in 2020, and direct recruits are appointed in 21, and 87 officers are promoted during this period from 17 to 20. So that is one problem. Now, my lord, in my respectful submission, this problem can be solved if there is proper and honest implementation of the roster system. Now, one of the most important requirements of the roster to operate is a yearly recruitment of 3 sources. if there is no yearly recruitment of three sources, then the implementation of the roster is bound to cause practical difficulties and problems. Therefore, in Malik Mazhar, your lordships had actually laid down a time schedule as to when the recruitment is to be made. And if that time schedule is adhered to and the recruitment is made in all sources, from all sources within the year, then in my respectful submission, the roster will operate and the roster will fully satisfy the aspirations of all the three batches. Now, two or three more things. First, your lordship said, how would the roster operate? Since the percentages for direct recruitment, promotees and merit promotees is to be worked out on cadre strength, the roster has to operate on cadre strength and cannot operate on vacancies. This is clearly stated in para 29 of the 2002 judgment. It is also clearly stated in Sabharwal, on which para 29 relies on. I have only half an hour, Lord. I will put all this in a small note, and because this is over yesterday, I have improved a lot of things. So the roster firstly has to operate on posts. Now, Sabharwal says that when you start the roster, you start, every roster says 211, 211, 211. Now, when you start the roster, initially, obviously, the entire cadre is available to you, and then you start and you proceed. Now, the second point is, why should the persons be fitted at the roster point, at the slots? That is very important, because once you fit the persons at the slots assigned to each category, every category will then get a representation in every 4 slots in the cadre. There will be no bunching. You will have 2 promotees, 1 direct, 1 limited in every 4 slots of the cadre at every stage. So therefore, when you then proceed to give any benefit of the service, whether it is a senior scale, a super time scale, or even deployment as a principal district judge, when you sit down to make the zone of consideration, within that zone, every person in every slot will be available. So my respectful submission to your lordships is that the solution which was given in the 2002 judgment, and in states where the roster has operated, there is no disparity. In Delhi, the disparity is because up to today, there is no roster. In fact, in the judgment of B.S. Mathur, your lordships in para 52, which in my written submission I have quoted, categorically said, we are now doing length of service, but from 6 onwards, please bring back the roster. Delhi has still not brought back the roster, even up to today. Even up to today, there is a length of service which is going on, and roster has been only brought back if direct recruit and promotee is appointed on the same day, only then. That is not a solution. It has to be a year-wise running account, which is necessary for a proper settling of the equities of all concerned. Now, my lord, so far as the principle of weightage is concerned, which is being argued before your lordships, there are 3 reasons why I say weightage should not be given today. First is, my lord, your lordships originally, when appointment to the post of additional district judges were made, there were only 2 modes of recruitment. Some did not have direct recruitment. It was either promotion or direct recruitment. The Shetty Commission records some states had 60-40, 75 promotee, 25 direct. Some had 2/3, 1/3. Your lordships then reworked those quotas to give a 25%, and I'm borrowing the words from the 2025 judgment of your lordships, my lord, to give an accelerated promotion within the cadre of the civil judges. So that accelerated promotion was given by carving out this 25% limited departmental quota so that they could work, so that they could proceed in a slightly faster fashion. This is a facet of weightage, which has already been given to them within the cadre. The man who would have to wait has one option of accelerated LCD and proceed further. Second, now this argument becomes all the more important because now your lordships have given within the junior to senior also an LCD. So now, actually speaking, and hypothetically, it may not happen, If at 24 I pass my law, 3 years I wait, 26 I get appointed as a civil judge junior division, then another 3 or 4 years I get promoted, I take the LCD and become a senior division, then another 4 years I will have to wait. By 34, 35, even within the promotion quota, I could be eligible to become a district judge. So therefore, my lord, this what you have granted, this what your lordships have granted to them now, to move from the lower junior to the senior scale by way of an LCD is also a sort of a weightage or an acceleration which is granted to the brighter of them, as Mr. Dwivedi had put it, that if a person wants to be patient and take the longer route, then it is, of course, each person has his own aspirations and his own thinking. So this is the second thing. The third now, your lordships have also opened the direct recruitment route to the subordinate judges. So therefore, if your lordship sees a subordinate judge who joins, first has an option to go in for direct recruitment. Then he has an option to take the LCD to move faster from the junior to the senior scale. And then he has another LCD to move from the senior to the ADJ scale. So therefore, my lord, now giving them another benefit of weightage, in my respectful submission, is not the solution. This is the second point that I'm making. The third reason for not giving them weightage is that your lordships in the 2002 judgment para 30 have categorically said that weightage should not be granted, and roster is the solution. And therefore, my submission on the first point being, roster has not failed actually. Roster has never been given a fair chance to operate fairly. And for a roster to operate fairly, yearly recruitment is a must. So therefore, if your lordships is giving some directions, then the directions would be that the observations made in Malik Mazhar for yearly recruitment should be scrupulously followed. That is my second submission. Now, my lord, so far as quota is concerned, so far as quota is concerned, my lord, I can do no better than reading paras 44 and 45 of Muhammad Shujat Ali, my lord. If your lordship will just have that judgment, because that is what is ultimately in Khosa, my lord, of Khosa, the Lokinath Khosa, that is volume 5A. If your lordship will have at page 49, placitum B, C, and D.
That's it.
5A. That's at 21.
But your lordships is coming back at 2 or is it?
No, yesterday only you said.
Yes, but then there was some circular which confused some of us. That the bench will assemble on Wednesday for the day or something like that. Didn't say for the day, it said bench will assemble, so we thought perhaps.
No, your lordship indicated that only till lunch today
Yes, yesterday only.
before rising your lordship.
So can I then get 10 minutes on the next, 10, 15 minutes on the next?
You decide amongst yourself timing.
No, 10 minutes only. I have hardly taken 15 minutes. I got a slot of, only 10 minutes on the next day, whichever next day your lordship is granted. Tuesday.
5-7 minutes, you can.
Lord, let me get it on the next day, Lord, 10, because.
They will not take 10 minutes, you'll take more.
No,
Yes.
I promise to take 10 with a maximum of 15, Lord.
Yes.
I'll just recapitulate and.
Get Wednesday, Thursday, Friday.
Time will not change. Time will not change, Lord. I will not take extra day.
Lot of time to get your ammunitions,
Grateful.
Your Lordship, there's been a fresh IA that has been filed. IA number has still not been given. If the court could allow, because the registrar is.
Maybe defect, you find it out.
Okay. No problem.